Hello and welcome to the Law Lab. Here we dissect and unpack everything legal. My name is Risa Iris Ewonia, and on my right I have
Aaron Asiedu Entry.
Welcome, Aaron.
Thank you, Risa. Let me extend a handshake. Happy New Year too.
Many happy returns.
You're looking so smart today.
Ooh, thank you so much.
Right,
you don't look bad yourself.
Thank you, and thanks for having me too.
You're welcome.
Right.
For those of you joining us from TikTok, I am sure you are aware that we are about to discuss the just ended general elections and the legal matters that arose after. So, Aaron, tell me, what happened after the elections?
Well, I think it is clear. We were all set for the December 7th general elections, having 13 presidential candidates. Unfortunately, running up to the election, we had our own mother, Ekuyadonko, passing out.
Oh, may she rest in peace.
Technically 13 on the ballot paper, but 12 actually, because the EC mentioned that if you vote for Ekuyadonko, it will be counted as a sport ballot. So 12 on the ballot. One would definitely emerge as victorious, and the other 11 will go home having to think and regroup and come again. So we all know it is clear that His Excellency John Dramani Mahama mounting his, I think, fourth attempt from 2012, 2016, 2020, 22, his fourth attempt, coming in as the seat president of the Republic of Ghana with posing over 50% of the vote as a one-touch victory, and having the MPP and the other 10 presidential candidates losing out. So basically that is what transpired in the general elections.
Then obviously we have to say congratulations
yes, congratulations to HE.
Yes.
It's not elected, it's been sworn in.
It has been sworn in.
HE, John Dramani Mahama.
That wasn't a mistake on my part.
We are only hoping that he would be able to rule the country as expected of him, since he's coming on board with a lot of experience amongst others.
I do hope he delivers as he said he would. Now, aside from that, what about the parliamentary elections? Because I believe that is where a lot of people have certain issues about. What happened after that?
Right. So, Rita, I think the Ghanaian elections, we enter into general elections voting for two people. One for the president and two for a parliamentary candidate who later becomes a member of parliament.
Oh, okay.
And the point here is that after mostly with our elections, the parliamentary elections determines how the presidential will go. Because if you have a majority in parliament, it means that you are going certainly, per the data available, you are obviously going to have a commanding lead in the presidential election. But this time around, we saw that the NDC coming out with about almost over 180 members of parliament.
Wow.
With the MPP running around 86, 87, 88.
That is a historic feat.
Yes, that is indeed historic. But the point here is that the number keeps on, dwindling or moving up. It's just dangling because there are some disputed seats that came out of the general election after 7 December. Most of our viewers and our listeners zoom in to celebrate the Christmas. I'm sure you were also enjoying the Christmas.
Oh, yes.
But you sent me as a member of the Law Lab to be in court because there were some disputes over some constituencies. Most especially, I'll start with 4 constituencies, which is known to the general public. That is Ablekuma North, Techiman South, Tema Central, and Okankwe Central.
Yes.
I think the issues even started with Nsawama Duaji and also Ahafuano being part of it. But throughout the process, let me begin with how the process started. So in Nsawama Duaji, Ahafuano, Techiman South, Tema Central, Okankwe Central, and Ablekuma North, the MPP actually went to court for an order of mandamus. I think with regards, this constituency was also part of Obuasi East and some few other constituencies.
No, before you divulge into what exactly happened in court, I just want to ask, what exactly is a mandamus? Okay,
so there are some 5 prerogative writs in the Constitution. When you pick Article 33, Clause 2 of our Constitution 1992, it will be on the screen for our viewers to actually watch. We have 5 prerogative writs that the High Court has the power to issue. 1 is mandamus, 2 is certiorari, 3 is habeas corpus, 4 prohibition, and the last one is quo warranto.
Okay.
So let me pick them one after the other to explain what it means. Then we zoom into the matter proper. When we talk of mandamus, it is an order from the court to compel a public officer to perform his public official duty. I'm using the word public because if it is against only public officials, when I'm having a private company, you cannot go to the court for an order of mandamus to compel me to act. And if you're a law student and you are watching us, mandamus is most popular in the case of Marbury versus Madison. Okay. And you put the case on the screen where William Marbury went to the court asking for an order of mandamus to compel Madison, who was the Secretary of State of the United States, to give him his commission. Those who have read about what we call a judicial review should be able to clearly know that. So that is mandamus. So let's talk about quo warranto. So an example is you can get, let's say, the Honorable Kessel Atoforsen, who is Minister of Finance designate, who probably might be running around town, or somebody who is a minister or a minister designate claiming that, oh, I am a minister, and you are doubting the person. Even if when the person has been confirmed and you still doubt the person, you go to the court for an order of quo warranto to compel the person to provide its authority. The authority that makes him carry that such office around, mentioning that he is a minister or any other public office. Then let's deal with certiorari. When we talk of certiorari, it's an order from the court to actually review or quash the decision of a lower court. So Supreme Court reviewing the decisions of the High Court, they can either set aside the ruling or the decision of the High Court or even quash it. So that is certiorari. And we have prohibition. Prohibition certainly has the name smarts. You get to know that you are prohibiting from someone from doing something or prohibiting him from further doing
a particular act.
Thank you.
Yes.
And the last one should be habeas corpus. Habeas corpus means, the simple understanding is produce the body. And if our law students are watching us, the popular case of Ria Kuto and 7 others will give us a very good understanding of what habeas corpus is. And when we talk of habeas corpus, all that we mean is that, let's say someone has been unlawfully detained and you go to court asking the court that the person who has been unlawfully detained, you want an order from the court so that they produce the body and the person will go through the right procedure of prosecution. So habeas corpus means produce the body. That is basically it.
Now, focusing particularly on mandamus, because I heard in your earlier submission that the mandamus was sought by a particular party concerning the 4 constituencies, which you mentioned as Tema Central, yes, Techiman South, and if you could help me with the rest.
Okankwe Central and Ablekuma North.
Yes. So you said a particular party sought the court for an order, the mandamus.
They made an application.
Yes. But who were they compelling to even act in the first place?
So Risa, let me even begin this way. The constituencies initially were about 6. As I mentioned, Ablekuma North, Techiman South, Okankwe Central, Tema Central, Nsawama Duachi, Ahafwano, and I think Obuasi East also. So these 6 constituencies, the MPP made an order or applied to the High Court for an order of mandamus, claiming that these constituencies I've mentioned, about 6 of them or 7 of them, the coalition by the Electoral Commission was not completed, and it was marred by the disruption of other political parties, hooligans, and also having the Electoral Commission's returning officers being forced or compelled to declare some constituencies, some or all these constituencies for the NDC. Let me cite an example. If there is a video evidence of Okankwe Central, where the returning officer declared 110 out of, I think, 141 constituencies, declaring it for the NDC parliamentary candidate as winner. So we saw a lot of petitions to the Electoral Commission by even the returning officers. In the case of Tema Central, the one who made the declaration was not the right returning officer for Tema Central. I think it was the returning officer for Tema West also who came in to make the declaration. So the MPP just brought all these constituencies together, made an application for mandamus to compel the Electoral Commission to actually be able to complete the collation of the electoral results, amongst others. And so in court, the NDC also tried to join the case, to file a joinder, and even had their lead counsel, our very own senior Eduji Tamaklo, appearing as a friend of the court and actually drawing the attention of the court that they have made an application for joinder. The High Court did not actually hear him on that matter and ruled granting the application of mandamus to compel the EC to go and collate to complete the collation of the parliamentary results in these constituencies. One thing I left in it is that the EC also, in the affidavit, mentioned that they want the court to grant the appropriate order so that they go back to complete their works in these constituencies, meaning that the Electoral Commission itself had admitted that they are not done with the works of declaring who is a winner or collating the parliamentary results in these constituencies. So the NDC, led by Council Eduji Tamaklo, filed an application for certiorari to quash the decision or set aside the mandamus order granted by the High Court. So in the Supreme Court, we had about 5 panel members presided over by His Lordship Justice Gabriel Puamai.
Not to cut you short, but I just want clarity on a certain matter. You said the NPP applied for a mandamus in the High Court.
Yes, please.
How did it go all the way to the Supreme Court?
So you see, whenever a High Court makes a decision and you want the said decision to be quashed, it is proper that you move to the Supreme Court. I don't actually want us to delve much into the technicality of it, since most of our viewers are not really well much versed in the law aspect. So going to the Supreme Court, as I mentioned, we had Justice Gabriel Puamai presiding over a 5-member panel, and Counsel Eduji Tamaklo for the NDC made a submission that on the basis of breach of natural justice, the court should quash the mandamus application that was made by the High Court or granted by the High Court for the MPP, in the sense that he said he was in court, he had made an application for a joinder, and that the High Court should have actually joined them to the suit in the High Court so that they would be heard. Unfortunately, that didn't happen. And the NPP on the other side opposed vehemently to the submission made by Eduji Tamaklo, Counsel Eduji Tamaklo. And they stated that, well, since he appeared as a friend of the court, he was heard amongst others. But the Supreme Court, presided by His Lordship Gabriel Puamai, actually granted the submission or the plea or the prayer of Eduji Tamaklo Esquire, that is the NDC, by ordering that they have set aside the decision or the order of mandamus granted by the High Court, and that they ordered that the MPP should actually file again at the High Court. I think the ruling came on Friday and ordered that the High Court should sit on the matter on the following Tuesday. So we were back again to the High Court to listen to the argument of both parties on the mandamus application again. Now we were moved from the previous High Court to a new High Court, which was presided over by His Lordship Forsen Ejapon in the Accra High Court General Jurisdiction 2. And in this, when we got there, they started the mandamus submissions on it. And surprisingly, the NDC actually came out with, led by Eduji Tamaklo, filed a preliminary objection to the mandamus application. And the argument is very simple. They believe that when it comes to electoral matters, you should come in a form of an election petition. And they believe that mere gazetting of the election results, with regards to parliamentary election, you must wait for the election, the results to be gazetted before you can commence an election petition, because after the gazette, you have 21 days to wait. 21 days to bring an election petition. But with regards to presidential election, just after the declaration, your 21 days starts to count. But with regards to parliamentary election, you have 21 days after the gazette. And so the NDC's argument is that they see the mandamus application as a form of an electoral petition clothed in the form of mandamus application, because they believe that just after the declaration, the gazetting is a mere process. And so after the declaration, the 21 days has actually kick-started. But the court disagreed with them on the following day when the court was making a ruling that no, this mandamus application is even in for the collation, not even recollation, for the collation of the electoral results. And so there has not been any gazette of the parliamentary election for one to say that a course of action will now lie for only electoral petition. And so the mandamus application was in its right way. So now submissions on the mandamus application began with the MPP actually stating their old position that the coalition in such constituencies had not been completed. In the Supreme Court, I left one thing out. In the Supreme Court, the court ruled that we should, in the constituencies of Nsawama Dueji and Ahafuano, that is Nana Agyemang Prempeh of the NPP, is conclusive. It shouldn't even be taken to what we call the High Court again. So for that, Nsawama Dueji and Ahafuano was out. Now the mandamus application was basically for these four constituencies: Okankwi Central, Tema Central, Techiman South, and Ablekuma North. That is what we were left in the High Courts now. The NPP made their arguments on, and also presenting evidence, video evidence of seeing some known NDC national executives shouting that they should bring the Electoral Commission out to declare, citing among others that even in Tema Central, the one who made the declaration happens not to be the returning officer for Tema Central, but for Tema West also. And also in Okankwi Central, they stated that the returning officer declared 110 polling stations out of 141 polling stations. One thing we should know is that the EC can actually make a declaration when all the polling stations are not ready. However, it is subject to the fact that the rest of the polling stations or the rest of the constituencies that are not in, even if you add it to the loser, it wouldn't actually make any significant change. You get it? But here, 110, leaving 31 polling stations were very huge. So the NDC actually argued that with regards to mandamus application, there are two elements you must satisfy. There must be a demand. You are demanding the public officer to do something, and a subsequent refusal of the demand, which will now give you a course of action that because I demanded A, he refused to do it. You are now coming to court to actually compel them to do the work. But the MPP also argued that necessity is an essential element in law, because when we look at the time frame, if you are going to now write a letter to the Electoral Commission for them to go and now respond in about 2 weeks, you have to wait for some period of time before you bring an action. As of that time, you would be waiting, or the time you would be waiting, the consequence of the matter would have actually been done already, and it will take you a long process to unwind or undo those things. It is why.
So you mean to say that the MPP have not even demanded the EC?
The MPP also proved in court that they had actually demanded, showed some writings and some letters in court. But you see, the crust of the matter is that even if they had not demanded, another leg of the argument is that necessity or time constraint is also a matter. Because if we tell you, and the MPP showed a lot of letters from the Electoral Commission stating that they themselves do not even accept that coalition and they were going to recollate and others. However, we should note that the MPP did not go to court for recollation.
No.
The MPP went to court for collation. Collation, that the Electoral Commission should be compelled to complete its work or its collation in the four various constituencies. So, His Lordship Justice Forson Japan of the Accra High Court General Jurisdiction 2, actually made a determination on the matter. He actually took these constituencies seriatim, one after the other, and stated that basically in all the four constituencies, he granted the mandamus application for the MPP. As we speak now, Okankwe Central is completed, Tema Central is completed, and also Techiman South is
also completed.
What is left outstanding is Ablekuma North.
Why? What happened there?
Before even I go to what is happening over there, Risa, surprisingly, as we were all in court and the ruling was being given, just immediately we close and move out of the court. We just saw in the media that the NDC, who we were sitting in court with, had rushed to file an appeal on the matter, even filing a stay of execution. And you know what stay of execution means?
No,
that the High Court can, when someone files a stay of execution, the effect is that the High Court cannot, or no one cannot actually execute the order of the High Court. They found that, and it was in the public. We were all surprised because honestly, I didn't know the time they got out of the court, and all of a sudden it was all over. With Ablekuma North, just as you mentioned, I think there are issues with the pink sheet because it appears the NDC cannot find their pink sheet. The MPP also claims that some of their pink sheets has been destroyed, amongst others. And I think when the hooligans also entered into the coalition center, the EC lost a number of pink sheets also. So I think they were having some 62 polling stations outstanding. It has now reduced up to about 2 polling stations, and we are hoping that by next week, that determination, the EC should be able to help fix that matter, and we all proceed to know now the number of seats the MPP will be having in Parliament, and also the number of seats the NDC will be having in Parliament.
But as it stands with the Ablekuma North, who is leading currently? Because you said it's left at 2.
Well, you see, the leading out, it shouldn't be in the purview of the law lab to be bringing it out, because it should be that of the Electoral Commission. But I could see the MPP with high hopes, thinking she will win, or believing that she is in a very comfortable lead. The NDC also actually, NDC's Rabina Obin also argues same. So we are hoping that the 2 polling stations will be sorted out, and we would have a very conclusive parliament. One thing, Rita, that came up is that as we were gearing towards finishing all this parliamentary higi-haga, people in court, New Year Day I was in court just to follow up and be able to bring our cherished viewers and listeners update on it. We heard that the Akwatia MP-elect for the MPP and also Fantiakwa MP-elect for the MPP had been injuncted. So quickly I had to rush to Koforidua to follow up, because Akwatia and Fantiakwa is in the eastern region with regards to their constituencies. So I was in Koforidua High Court to follow up with the proceedings. In Akwatia matter, the injunction was granted by the High Court against NS Yaukumi, who is popularly known as the Akwatia Starboy. Now he has been injuncted not to be sworn in or to hold himself as what do we call it, a member of parliament for the good people of Akwatia. But in Fantiakwa North, something surprising happened. With all hopes that the hearing would be on the seat to hear both parties and ruling will come so that we know the way forward. Funny enough, surprisingly not funny, the judge came out telling us that he's from Begro, the wife is also from Begro. That is where Fantiakwa North is, their capital. And he knows both the MPP and the NDC. So he recused himself. And actually referred the matter to the Chief Justice for subsequent advice. And so he adjourned the matter sine die. But the Akwatia MP, whose injunction was granted, together with the Fantiakwa North MP, were in Parliament to be sworn in. Also, the 4 parliamentary constituencies we are talking about, Ablekuma North, Techiman South, Okankwe Central, and Tema Central, of which the NDC had filed an appeal and also a stay of execution of the order of the High Court. They were all in court and they have been sworn in. They are part of the MPP caucus. So we are looking at the next line of action from the NDC, and surely we shall be in court to come back and report to our viewers.
So when next is court sitting to talk about this?
We have not been updated yet, and when we get the updates, we would kindly share it with our viewers and follow up.
All right. So thank you, Aaron, for educating us on the legal matters that arose out of the general
Thank you so much.
elections.
You're
It was
most
a
welcome.
pleasure having you.
The pleasure is all mine.
Thank you.
All right.
To our cherished viewers, we are so grateful for joining us on this session and being educated on the court matters that have arisen out of the just ended elections. As stated earlier, we hope Aaron will keep us updated on the court proceedings concerning these elections and their subsequent matters.
Sure.
Don't forget to follow, like, subscribe, and share to your friends. Thank you for having us.